The first thing you're going to be looking at when you're doing this, as I'm sure most of you know, is you're going to be wondering, is this claim directed to a process, a machine, a manufacturer, or a composition of matter? If what you are trying to patent is a naked mathematical formula, you are not going to be able to patent this. The Supreme Court has used if someone tried to patent E equals MC squared. If that was your claim, how are you going to get around 101, and what do you do when you get a 101 rejection? Look at your background section. It's hard to state what you are improving if you've not said what was before.
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, Daniel Cole. For over a decade, Daniel Cole has guided independent investors, startups, college professors, industry professionals, and established businesses through the complexities of intellectual property law. As a registered patent attorney with a specialized focus on chemical and biochemical companies, he evaluates patent and trademark eligibility, drafts IP applications, and advocates for clients in both protecting their rights and defending against unjust infringement claims. The webinar presentation that you're about to watch will be approximately 1 hour, and if you have any questions for Daniel, we will be taking those at the end of the presentation, and you can always submit those by clicking the Q&A button in the control panel at the bottom of your screen. Now, without further ado, here is Daniel Cole to discuss advanced patents examining 101 rejections to strengthen your applications.
Hello, okay, got that working there. So, as she said, I am going to be talking about surviving the 101 analysis and talking about looking at patents and making sure that you're going to not get rejected for being looking over 101. First, a little bit about me, my firm. I work at Chambliss. We are a full-service law firm, patents, healthcare, intellectual property, business law, real estate, criminal, labor, and employment. Information about us there. Okay, we got a lot to talk about. This is a fairly complicated topic. If you came to my previous one, this is several jumps ahead of that one. So buckle in and let's go ahead and get started. I've subtitled this one Strengthening Your Walls Concrete, because what we're going to be talking about is how to make sure that if you go to file a patent, you can recognize if you're going to have a 101 problem, what to do about it when you're writing the patent to see, what you can do to make sure that when you get that rejection, you're prepared to fight it. And then a little bit about how, when you get that rejection, you can fight it. Part of this is going to rely on some changes that were made in 2019 to the way the Patent Office looks at 101 analysis. Now, don't be scared. This is a very complicated little diagram here. This is a bit like the diagram that the USPTO put out in 2019. We're going to go through each of these steps kind of in very in-depth detail to make sure that this is understandable, but did want to show this for you first. So the first thing you're going to be looking at when you're doing this, as I'm sure most of you know, is you're going to be wondering, is this claim directed to a process, a machine, a manufacturer, or a composition of matter? Now, most things are, but there are some things that are not. And there have been some cases where things were found patent ineligible because they are not a process, machine, a manufacturer, or a composition of matter. But after that, you generally get to the main focus of today. Is there what is called a 101 exception to patentability? The first question that's asked about this to determine this is the claim directed to a law of nature, a natural phenomenon, or an abstract idea? Law of nature and natural phenomenon have generally blended into one thing. Abstract idea is very complicated does not mean what you would think of when you think, oh, it's an abstract idea. It's not specific. Doesn't really mean that. Arguably, what it means, the Supreme Court has not said, maybe doesn't know. But if it is directed to one of these three things, there are two things. There's a new question that is asked by the Patent Office. That is the exception integrated into a practical application? This is important because if it is integrated into a practical application, at least at the USPTO, you then stop the 101 analysis. You say, yep, this is integrated into practical application. It is now patent eligible. This is not a step that was directly outlined by the Supreme Court or any other court. It's somewhat questionable how courts are going to react to the inclusion of this step by the Patent Office, which we're going to talk about in more detail later. I just want to tee that up now. If it's not put into a practical application, according to how the Patent Office defines that, you then can still get over the 101 analysis by what is the original second question asked by the Supreme Court. Is there something more than well-known activity that integrates the exception into something more? Okay. So let's talking about each one of these in depth and a little bit about strategy for each one of them. So the first thing is whether you've got a machine, a process, a manufacturer, or a composition of matter. And like I said before, this is likely that something that most things will fit under, but not everything does. Fun thing in a patent class in law school, teacher generally asks people to think of things that are not a manufacturer, process, composition of matter. People generally come up with things like, oh, I don't know, love, that obviously you're not going to be able to patent. The first case that talks about this, that's important for us, is Henry Ferguson. So in this case, it's a really complicated kind of computer case, but generally you have a marketing company that is going to market software from a plurality of software companies, not its own company. It's got a bunch of other companies that make a plurality of software, and it's marketing these plurality of softwares. And the other softwares, these softwares that it's marketing, carries out and pays for marketing activities. And the marketing company, because of the software that they're marketing, gets a return on a share of a total income stream from the marketing. In this case, what's important for us, the claims were not laid out as a process because there were no series of steps. Since it was not laid out as a process, there wasn't a series of steps, Supreme Court said this is not a machine, a process, a manufacturer, or a composition of matter. So if you have what's generally considered a business method, make sure that you have a series of steps in your claims and that things are laid out obviously as a series of steps. Okay, this is to help you get around at least this first part of the 101 analysis. As we'll talk about later, business method patents are generally very hard to get through, especially because of the abstract idea exception. But if you have a claim or a series of steps, you'll at least get through this very first part of whether it is a process. So now it's in the things that can be patented for being a process. The other one, this is Henry Nugent. And this one was entertaining. This is a signal that was embedded with supplemental data. And because of the way the signal was encoded, it allowed certain methods of encryption. Now, the claims that were under consideration here, they really didn't claim they tried to claim the signal itself. They didn't claim the process of making the signal or the process of using the signal. They just tried to claim the signal. The court basically said this is not a new type of manufacture. It's not a new type of matter. And they actually quoted, we are aware that energy equals mass times speed of light squared. This does not in any way change our analysis. So despite the fact that energy can be matter, here it is not, according to the court. So this is not matter, so it is therefore not a new composition of matter created by man. It's not manufacturer because it's not tangible matter. Your guess is as good as mine exactly what a court might mean by tangible there. So, here, if you've got something that involves energy, radio waves, make sure you claim the process of making or using those radio waves, along with maybe throwing a thing in for the energy or the wave as well. Expect not to get that. So the simplest way to, say non-transitory is, talk about the way of storing the medium. All right. Maybe not the best, but always you don't want to include electromagnetic waves. So let's think about for a moment if this is something that would fit into a machine, a process, or a manufacturer. And there are going to be things like this in here where I'm going to give an example, and then I'm going to, I'll give you a little moment to think about it, and then I will talk about this. If you've been here before, one of my lectures, I mentioned I used to be a community college teacher. If we were in a class, I'd actually, walk around and help people think about it, but can't really do that here, unfortunately. So I'm no extra credit to figure out where this example came from, but the example here is, would this fit in a machine, a process, or a manufacturer? You've got a communication, and this form of communication comprises visual notations, and these visual notations are drawn simultaneously from opposing ends toward each other, and they're paired with audio cues. And depending on the way you do the auditory cues, you can modify the meaning of the visual notations. So one visual notation with an auditory cue might mean one thing, same visual notation, different auditory cue means something different. Okay, so think for a moment about how you would decide if you're going to, how you might make this fit into a machine, a process, or a manufacturer, using the things that maybe I talked about before. Okay. So this comes from the movie Arrival, and is how the actual aliens communicated in the movie Arrival, which I thought was very cool. We're going to come back to this example a little bit later when we talk about things like abstract ideas. But here, if you did this as a process, if you said, a process of communicating, including making a visual depiction, changing the meaning of the visual depiction with an auditory cue, you would then have a process that would at least go through the first step of saying, yep, this is a process, so it is going to be patent eligible. Okay, if you tried to do it in some way with it wasn't a process, this is not going to be a machine. There is not really a new state of matter here. There's not really something that you're manufacturing. So you can't really get away with this in any other way, but I would think than making this a process. So we talked about its claim directed to a process, machine, manufacturer, or composition of matter. The next thing, as we looked at on our first other chart, is the claim directed to a law of nature, a natural phenomenon, or an abstract idea? First of these is going to be the law of nature, natural phenomenon, product of nature, which you'll also sometimes see in the case law and when other people talk about this. Generally, this is really all of the same thing. It's something that existed before you found it and in nature. If what you are trying to patent was found in nature before you discovered it, you're generally not going to be able to patent it unless you do certain specific things. In the days when somebody can go into the jungle, find a new compound that treats a disease, and patent the compound, the new compound that they found in the jungle, are gone. Not really can't just do that anymore. So, example of things that have been found to be laws of nature or natural products. The Supreme Court found that unmodified DNA, newly discovered genes in the Myriad case, which kind of started a lot of the stuff here that led to the most recent a 101 push. Correlations between drug amount and treatment success. Mayo, a pair of the Mayo Myriad. You probably have heard about the Mayo Myriad two-step. Those were the two cases that kind of pushed off this new 101 emphasis. But, they reached back to earlier cases to do this when they developed this. They reached back, for example, to Morse, which was an 1854 case, but is still very much cited in 101 cases, where Morse tried to patent electromagnetism that transmitted signals. Didn't use really the fact that was energy and not matter or not a process. They talked about that it was the electromagnetism existed beforehand, so it was a law of nature, and that you couldn't patent it for that reason back in 1854. Post-Mayo, the Federal Circuit has found non-invasive prenatal diagnosis procedures to be a natural phenomenon, not patentable, and intron sequence analysis method of detection of adjacent and remote locus alleles as haleotypes. I've got both the cases there. This is very complicated science. I'm not going to talk a lot about that. We've got enough in the law to talk about, but those are there if you want to look at them. So these are things that, generally you're going to find. If you have that, you're going to end up potentially having a law of nature, product of nature exception that you're going to have to deal with. Warning things for this: if you have a chemical entity that has a correlation of nature in nature, you're going to run into this problem. Now, this is true even if you have a mixture of natural products. The case for this, there were bacteria that were used in fertilizers to keep off various pests. A guy, I think with Flock, tried to put all of these different types of bacteria together, but he didn't do anything to change any of the bacteria. Since he didn't do anything to change any of the bacteria, even though they weren't found naturally together in nature, we're just like, that's just a mixture of natural products, not patentable. That's the Parker v. Flock case that was in 1978. If you have got a correlation of chemical amounts for a known chemical, and you're correlating that amount of the chemical to a human-animal reaction, you're going to run into this problem. This is the Mayo case. If all you're doing is you're doing a correlation of known amounts of a chemical, like in the human body, and saying the correlation of this amount of chemical being present means this disease is present, and that's all you're doing, you're going to run into a warnings having of a natural product or a product of nature. Okay? So these are the kind of things to be on the lookout for. If somebody comes to you with one of these, all right, this is going to be an issue I'm going to have to look at, and then be prepared to do so. One of the things that you can do to get around this is have significantly different characteristics. This is a way to say, okay, what I'm patenting is actually not the item that is in nature. It has significantly different characteristics from the item in nature. So therefore, it's not the item in nature, and it's not a subject to this exception. Okay, this is not really going through the steps that I had up front. This is like a corollary that only exists for the biological items. This doesn't help with abstract idea. Okay. It's a way to get around somebody saying this is a product of nature. So if you get a product of nature exception, but you can go, oh, wait, Mike, the characteristics of what I have are very different than this item in nature, and you can prove that, you can now get around this exception. So you have to compare what you're patenting to the natural product in its natural state. Kind of things to consider are going to be things like biological or pharmacological activities. If what you're doing has a different biological or pharmacological activity, it is not the same as the product in nature. You can now get around this exception. If it has different chemical or physical properties, you can now get around the exception. It's not a product of nature. If the phenotype, which includes structural and functional characteristics, if those are different, it is not the product in nature. This was how we got around human modified DNA and Myriad. You're making cDNA by taking out the introns. That's now not a product of nature. You're putting it back together, you have the cDNA. It now has different structural and functional characteristics, not the same as a product in nature. So it is now not subject to the exception. Again, and that's kind of the same thing with the structure and form, whether chemical, genetic, or physical is different than the item in nature. You now don't have the same thing, so it's not subject to the exception. Now, arguably, you might run into problems later if what you do is obvious and conventional, because when they're looking at these significantly different characteristics, they don't consider that. But as you know, they're going to consider this when they go down the line. The USPTO has some great examples, but these examples are only about getting around this exception by showing that you have significantly different characteristics from the product in nature. You can look at an NBP example 2. They talk about a pomelo fruit with preservatives that prevent spoiling. If you have this, fruit and it has this preservative, even if it's a known preservative that's been known for a long time, what you have is now not a product of nature. Whereas if you were found this new fruit and you tried to patent the fruit, you're not going to be able to do that. But do you run into obviousness problems? Probably, because you're just taking an previously unknown item, certainly a fruit, but you're pairing it with something that's already known to get an obvious result. A natural product drug, you've got to find this drug in the environment, but you coat it with a coating that's known to slow metabolism. You now have a significantly different characteristics from the item in nature. But again, since you're using something that was known before and is going to combine with the natural product in a known way, may run into obviousness problems. You're taking a known fluorescent label, you're attaching it to a natural nucleic acid. Naturally, this nucleic acid does not fluoresce. You're making it fluoresce. It's different than it is in nature, so you're not going to run into 101 problems. Quite possibly, you're going to run into obviousness problems. So that's just there to say, make sure, you're not solving one problem, but creating another, and be able to tell your client, okay, this is not going to work. What are we going to do differently? And maybe what you tell them is, because of the current patent law, we have to keep this as a trade secret, especially if you've got a diagnostic. Probably better to keep it as a trade secret. Talk a little bit about ways to go around diagnostic problems later. But generally, very hard to patent diagnostic techniques right now. Maybe best to keep those as a trade secret rather than trying to patent them. So, however, I like to call this the slap on the learning hand. It has to be something different than just separating the product from its natural setting. There's a very famous case written by Learned Hand, who's a name of a judge, that talked about that something was not a natural product if you have purified it, because you've now increased its concentration and it's not in this concentration when it's found in nature. The Supreme Court has said, no, that's wrong. Learned Hand was not a Supreme Court judge. So these cases were the first time really that somebody had tried to make that argument. Supreme Court said no. But if when you are purifying it, somehow in the purification you change the structure, then it's not the same product that it was in nature. Here, the example in NPB4 by the Patent Office, you have purified it, and in the fact of purifying it, the crystal structure changes. You've changed the structure of the chemical. It is now not what was out in nature. And since it was not what is out in nature, it's now not subject to this exception. So let's talk about would this have significantly different characteristics, or is this something that is not going to have significantly characteristics, and what might we do to give it significantly characteristics, maybe without running into problems with for natural products or being something that's obvious. So before I get to that, I want to address one question that came in. Talking about that the current patent law, it appears the law is promoting the introduction of products that may not be safe and effective, but are patented. The Patent Office really isn't concerned whether about things are safe and effective. That's the job of the FDA. The Patent Office deals with, is something new? Is it non-obvious? Is it something that is different than what was out before and different enough that it can be patented so the person who found it can prevent other people from making and using it? Whether it works in the market, whether it even does really what the person patenting it says it's going to do, is the way we have it set up, not the job of the Patent Office. The FDA, especially for drugs, looks at whether drugs are effective, whether they're safe. And this is an extremely complicated process that is long, that is rigorous, and is generally effective. Not always, certainly, because no thing created by humans is completely and utterly effective always. But the FDA is very stringent about things that it lets in and making sure that they are safe before they're let in, especially in drugs. Not something that I deal a lot with, but they're very well-done lawyers that deal with FDA regulations. And very complicated ways, things that there's the Orange Book that relates between drugs and patents, relates between FDA things and patents. Very complicated, separate but related section of law. So, okay. So we're running a vaccine. We're going to carry a mixture of 3 different types of live flu viruses. These types are usually not seen together in nature. If all of you have done is put these 3 types together that are not together seen in nature, you've really only done the Parker v. Flock thing that I mentioned. This is likely not going to be significantly different than in nature, according to the courts. So you're going to run into problems with the 101 exception. If you wanted to make one of the flu viruses fluoresce, maybe that, now you can patent it. Generally not going to be obvious if you use something that already is known to make things fluoresce, but you'll get around the 101 exception. And if, again, the FDA would then assess whether adding this fluorescence keeps the item safe, if you were going to give this to some 2 patients. But here, all we're worrying about is, can you patent it? What happens after you patent it, whether you lose your money, whether you make your money, it's not Our concern here today. Funk Brothers is this case from 1948 that I mentioned before, still cited, and would say this is not going to be patentable. But let's say if we change this, you have a three type of flu viruses, and for some reason in nature, these three types of live flu viruses, they kill each other. Okay, the viruses not only attack human cells and give the person flu, they would attack each other and kill each other, which, not generally going to be useful in that format in a vaccine because you want to give the person resistance to the flu viruses. If one kills the other two, you're only going to get the resistance to the one flu virus that's left. If you change the item somehow such that they now do not kill each other when they're not killing each other anymore, you're going to end up saying, okay, this is not the way they are in nature. Since this is not the way they are in nature, they're not going to be a 101 exception. You've gotten significantly different characteristics. Since you've got significantly different characteristics, you are now not subject to the 101 exception. This is a May 2016. It's the life science example. You have a natural peptide. You've mixed it with a pharmaceutically acceptable carrier. Again, probably going to run into obviousness problems here down the line, but the pharmaceutical acceptable carrier was not with the natural peptide in nature. And since it's not with the natural peptide in nature, you are now not going to have a 101 exception. And this is from the May 2016 life science examples. Before I talk a little bit more about how you would get around 101 exceptions generally, let's talk about how you would decide if what you have is going to cause an abstract idea exception rather than a life science exception, a natural product exception. Now, as I mentioned, this is confusing, okay? Part of that is confusion comes from the fact that it really does not mean abstract in a dictionary sense of not specific. If you look at the patents that have been declared abstract by the courts, the claims are very specific. The claims are not maybe not as specific as they could be, but when you write a patent claim, you're not writing a mechanical engineering manual. So it's not going to be A to B, unless you're doing a picture claim. It's not going to be that necessarily specific level of specificity. But we're not talking, the Supreme Court here is not saying you can't patent something because it's an abstract idea if it says, putting people in a cylinder with wings and flying them from one location to another. Like an abstract way to describe an airplane. That's really not what this is about. But the Supreme Court has refused, maybe not too strong a word, to really define what they mean by an abstract idea. Basically, what they have said is, we'll look at the things we have said that are abstract in the past. If it is like those things, it is abstract. The Patent Office has dealt with this case law by placing cases into three broad categories: mathematical concepts, certain methods of organizing human activity, which is very helpful, and a mental process. Okay, so if what you have is a mental process, a certain methods of organizing human activity, and mathematical concepts, you're going to run into it being an abstract idea. Now, we're going to go through each one of these and talk about what each one of these means, because if I would assume is fairly obvious here, these are very broad things that in of themselves are not very useful. Now, if it is not one of these, according to the 2019 USPTO guidance, it is not an abstract idea. They did give themselves an out if the technological center director approves and justifies. You can call something an abstract idea even if it doesn't fit into one of these categories. When that would happen, I don't know. Maybe in the plain example that I gave before, I would argue there would be better ways to say that that's not patentable with 112 rejections, but that might be an example of where you'd get, the technology center director would say, this is an abstract idea. Here, this justified these reasons. But the three that the patent office currently uses are mathematical relationships and formulas. This one's the easiest of them to understand. If what you are trying to patent is a naked mathematical formula, you are not going to be able to patent this. The Supreme Court is used if someone tried to patent E equals MC squared. If that was your claim, boom. You're not going to be able to patent that. It's a mathematical formula. Again, 112 maybe would be a better way to do this. What are you doing with this mathematical formula? But abstract ideas, what the Supreme Court has decided to use to do that. The things that have fallen under this were an algorithm for converting binary coded decimal to pure binary. Not being a computer person, we mentioned at the beginning, I'm a biochemist, so don't ask me to explain what that really is. If you're a computer person, you probably know. But if you're using an algorithm for that, this is said was just a mathematical equation, and this is now a problem with getting an abstract idea. You've got a formula for computing an alarm limit. I don't think that's not Parker v. Flock. That case cite there is incorrect, but sorry about that. But the formula for computing an alarm limit is also found to be a mathematical relationship and a formula. A formula for describing certain magnetic standing wave phenomena and Arrhenius equation use. This is Diamond v. Deere, which was able to be patented for various reasons, other reasons, but was the mathematical form relationship and formula that was a 101 exception. They were able to get around it, though. So, fundamental economic practices. This is really going to be a thing if you're what you have as a business method, especially if that business method is something that has been done before in the past and you just throw a computer at it. Talk more about that in a moment. But, these are ones when you look at these specifically, the claims are not what I would call abstract. Arguably, maybe 103 would have been a better way to reject these. Reasons known unto the Supreme Court only, not the way they decided to do it. Hedging, Bilski v. Kapos, was a fundamental economic practice, was therefore an abstract idea, fell under the 101 exceptions to patentability. Mitigating settlement risk, Alice Corp v. CLS Bank, again, fell under the abstract idea way of making something not patentable because it was a fundamental economic process. All right. And the last one were certain methods of organizing human activity. I'm going to get back to an idea of itself here in a moment. These are really close to fundamental economic practices, but computing the price of a fixed income assets and generating financial analysis report was considered to be a certain method of organizing human activity and therefore an abstract idea. And creating a contractual relationship was a certain method of organizing human activity and an abstract idea. Now, the courts and the patent office kind of have this broad catch-all category that also includes things as an abstract idea that's called an idea of itself. My example of the very broad description of an airplane probably be an idea of itself would be how they would include that as an abstract idea. The things that courts have looked at and the patent office looks at to figure if something is an abstract idea, these generally are what I would call things that are more abstract as opposed to specific. If your claim is result focused and if it effectively covers any solution or to the problem that you're facing, what you have is probably going to be an idea of itself. Things we've done this or collecting or comparing known information and Clausen immunotherapies, using categories to store and transmit information, and displaying advertisements in return for access to classified business material. So that was a very interesting case to read. These kind of things, this is what I would call abstract. These are great ideas, but not very drilled down. So do look for that. That still does qualify as an abstract idea, but these other things also do qualify as abstract ideas. Are these going to be an abstract idea? A mathematical formula used to measure ability to throw on the run and incorporates running speed, speed of hand to ball transfer, and speed of a thrown ball. This would be something that you might do if you were looking at baseball and, you're doing the money ball situation of trying to decide who a team should pick up. I know you've got a website that sells licensed products and you're going to organize those by the licensor, then type of product. And then you've got a bimodal language with both a verbal and a written component, where the verbal component can change the meaning of the written component. This is for my machine and matter transformation example before, the one that does this. And we are running low on time, so I'm just going to go through these. The mathematical formula one, if all you're doing is doing the formula itself, that's likely going to be an abstract idea. There are ways you can get around that we'll talk about in a moment. The website that sells licensed products and or just how you're organizing them, that would be a certain method of organizing human activity, would be an abstract idea. Your bimodal language, I would say that's going to be an abstract idea potentially. And you're going to be forced to, get that to work and make sure, we've got Morse. That could be considered something based on Morse that would be an abstract idea, would be maybe a product of nature. Okay. Well, so you've got this 101 exception. What do you do about it? And kind of the important thing here is, have you integrated it into a practical application? This is the new 2019 thing added by the Patent Office. This is pretty important because it actually means, when you're looking at this, as we'll talk about, you're not looking at whether what you're doing is obvious or non-novel. So you can maybe get around 101 a lot easier than you would in the past. That's also where we run into problems with how courts might define these. So integrate into a practical application, improvement to technology or technical field, like a computer. Application or use to affect a particular treatment or prophylaxis for disease. This is what you might do for diagnostic procedures. You talk about the diagnostic procedure and you include something that leads to a particular treatment. Maybe now you can kind of backdoor the diagnostic procedure in, even if the treatment is well-known or obvious. Use of a particular machine or manufacturer that is integral to a claim. We'll talk about what that means. And it affects the transformation of an article to a different state or thing. We'll talk about what that means too. There's one case that particularly talks about both of those. Things that have not been said to be integrated into a practical application. Merely use a computer to perform or implement an abstract idea. This kind of comes from the methods of organizing human activity cases and the economic activity cases, where you have something that's been done before, basically, and all your claim is doing it on a computer. Not, according to the Patent Office, integrated into a practical application, not going to be patentable. What you add is insignificant extra solution activity, or you're just generally linking the use of a judicial exception to a particular technological environment. So, what I said before, this does not take into account novelty or inventiveness. So, well, how do you make sure your thing is looking at is a practical application? Well, I like to call this the revenge of the background section. If you've been doing patent law for a while, you were probably taught that the background section is basically worthless, that you shouldn't spend a lot of time on it, that nobody does, nobody ever reads it. Well, one thing you can do in the background section is you can emphasize the practical applications of what you're doing. And you can set up the rest of your application to emphasize the improvement or the problem that you're overcoming, because your background section talks about what the problem is. A lot of 101 cases, the reason they were said not to be a 101 exception was because of things that the court cited that were in the background section. Same thing at the Patent Office. And especially if you're trying to say this is not a 101 exception because I've integrated it into a practical application, you can use your background section to do that. You can also make sure your claims focus on practical application. The most important case to look at for this is Vonda. This was a hair-splitting example where they recited specific doses of a drug. And the fact that they recited those specific doses of the drug in the claim made it eligible. Okay? So if you've got a diagnostic patent, which this was, add treatment claims. Even if those treatment claims are well-known activity, that's evidence of a practical application. Because you're curing a disease, and this is something that is practical. But you must limit the drug and the dose. It must not be a mental step. Okay, you're going to look at the October 2019 examples 43 to really get an idea of what this means. It has to be something more than a doctor recognizing and treating the disease. You have to add something like the doctor recognizing and treating the disease with this drug in this amount. And you have to make sure that it's a meaningful limitation of the claim, and you're not trying to tie up the judicial exception. Maybe add something like the cheapest way to measure and use. Add radiography, add fluorescence, add a porcine antibody. This does limit your claim. So this is where you come in and say, okay, do we want to patent this and limit it in this way, or do we want to just keep this as a trade secret? And that's going to be a decision between you and your client. That's a discussion you're going to have. For our abstract idea cases especially, it's going to be really important that you can disclose the improvement and the problem that you're overcoming. Again, background section. So, Vonda, the case I mentioned earlier, and the USPTO see this as step one of the Alice-Mayo framework. Vonda dissent did not see it this way. This is important because in step one, the way the Supreme Court has outlined the Alice and Mayo framework, you don't have to include whether things are novel or obvious. But the second step, you do. So this gets you around having to get to the second step of Mayo, where if you look at things are novel and non-obvious. But this means that it is questionable how courts are going to react to this. The NPP example 28, it's likely that Claim 3 would become eligible under the new USPTO guidance, when before, in this guidance, the PTO said this was not patentable. Originally, with example 28 of the example from the Patent Office, you have a new influenza A viral strain for pigeon flu. Claim 1 was a mutated pigeon flu virus that's non-effective but highly immunogenic. It's a mutation that does not occur in nature. You're going to have markedly different characteristics here since you've mutated in a way that is not known in nature. Claim 2, you have a formalin inactivated virus. Because of the formalin inactivation, you have structural changes, leads to inactivation of nucleic acids because those nucleic acids are chemically modified. These chemical modifications are not to occur in nature, and you have now a non-infective virus, so you have markedly different characteristics. Claim 3, peptide F mixed with a pharmaceutically acceptable carrier. Peptide F is a naturally occurring peptide isolated from pigeon flu. You don't change the structure or the functional characteristics of peptide F. You're just adding a pharmaceutically acceptable carrier. And importantly, this pharmaceutically acceptable carrier is not attached to peptide F. Okay, so you're not changing the chemical structure of peptide F. So it is just a mixture of two naturally occurring components, no change in structure or function. The claim can include, the way it was written, you can include a carrier such as water, which is now well understood and conventional. Since it was well understood and conventional, it was not significantly more, which is that second step of Mayo. And since it's not significantly more, it doesn't pass the second step of the myriad Mayo two-step, and so it is ineligible. But, if we're going with the new guidance, we've got peptide F and a pharmaceutically acceptable carrier. First step is the same. You're going to look through this and say, okay, this is a state of matter, but it's a mixture of natural components without the change in structure. So new, significantly different characteristics. Now we look and say, okay, is this a practical application? Well, it's a vaccine. I would call that a practical application. Now we're talking about this pharmaceutically acceptable carrier, and we're including water in this as a potential pharmaceutically acceptable carrier. But whether it's routine and conventional is not considered. We're using this as disease prevention, making it akin to disease treatment. We're considering the human body an article before the vaccine. Body is not immune, afterwards it is. So we are now transforming the human body maybe into a new state or thing. So now have we changed this into a patentable not exception to 101? I would argue maybe you have. So, and there's not really been new case law or new law from the Congress. So is this 2019 edition of Practical Application going to stand up in court? I am not sure. So if what you are basing the patentability of what your client is bringing you on is this, it's integrated into a practical application, just be careful and inform your client that, courts may decide this is not enough. Make sure maybe that you have a way to get through that second step of the myriad Mayo two-step, if a court says, yeah, this integrated in practical application doesn't matter. It's not case law. Ways that you're going to increase the likelihood, maybe. You could add that this is a method of conferring disease resistance. It's pigeon flu comprising. And then you could add a limitation to the vaccine having a certain seroprotection level. Now you're certainly saying, I am integrating this into a practical application. I have made it so that I'm going to make the human article resistant to this level of to the disease. So this is potentially going to, however, may give rise to potential 103 issues. This is a bit of a side. Just going to go over this quickly. When you're doing obviousness, you've got peptide F, you've got a pharmaceutically acceptable carrier. Obvious claims most commonly find two things in the prior art. What you're doing is combining them. The way you're combining them is obviously if you look at peptide F and presumably say that peptide F is not in the prior art, maybe you remove peptide F from your claim to make it consideration as a natural product. Some people, of course, muddled on whether this is going to work or not. Some cases seem to say yes, but this is within a 101 analysis, not a 103 analysis. So, you're still going to maybe get a 103 rejection if you have this, despite the fact that peptide F is not in the prior art. I say, well, it's a natural product, so we're going to act like it is in the prior art. So, you still might say this is going to be obvious, even in this example. Okay, so there's a lot. Summary of this. Improved into a practical application, improvement technology or technical field, application to use or affect a particular treatment for a prophylaxis or disease, use of a particular machine or manufacturer integral to the claim, affect the transformation of an article to a different state or thing, not integrated into a practical application, merely use a computer to perform or implement an abstract idea, insignificant extra solution activity, or generally linking the use of a judicial exception to a particular technological environment. The last thing, even if you have not integrated it into a practical application, you have to have, is there something more than well-known activity? Is there something more than the exception that is going to get you into patentability? And this is what you might want to make sure you have, even if you are relying on the integrated into practical application. So it's somewhat unclear how courts are going to react to that addition by the USPTO. Things that have not been considered significantly more for biological activity. Abstract is going to be separate from this here. Routine and conventional techniques. This is the same as the 112A analysis. So this is where if you have a diagnostic invention, be very careful. Detecting a disease-causing item that was eligible. But if you have an addition of a diagnostic step, it's now going to be ineligible. This is from the Patent Office example 29. Kind of unclear how courts are going to react to that. Remember biological examples, one of the things is that you can find a natural law. If it is a natural law, it is not going to be patentable. This is not going to be enough. Even if it is a natural law that was not known in the past. You have genetic technologies v. Muriel, which was a previously unknown natural law. Doesn't matter, was a natural law, not patent eligible. Rapid litigation management is a little different. Seemed like maybe what they were saying was that they found an unknown natural law. Exactly where the line between those two cases is difficult to judge. If you're just isolating it, however, remember we're no longer in the learned hand world. That is not going to be enough. We have amputated the learned hand here. Park Davis and Company v. Mulford and Chromadex v. Elysium Health would be the case there to look for that. All right, so that's what's not significantly more. How do you get to significantly more? Your specification, especially if you're doing biology, describe everything. Even if it's arguably covered by 112A, even if what you've got is routine and well understood, don't act like it is. If you don't say it's well routine or understood, the examiner has to prove that it is by expressly statement in the specification by the applicant. If you say it's well routine and understood, the patent office is going to take you at your word. Or by a court decision specifically discussed in this section of the MPEP, by a publication, or a statement the examiner is taking official notice. Now, we all know examiners, overworked, underpaid. Are they going to want to take the time to do this? Maybe not. So if you describe everything, don't say that anything is well and understood. It's going to make your patent long, but will help you get around potentially a 101 rejection. Make sure that you focus on the novelty and the markedly different characteristics of what you're doing. Use of cool melt PCR for gene amplification, use of scanning near-field optical microscopy to detect hybridization, use of porcine antibodies to detect presence of human proteins, and maybe consider adding claims just to the activities that are like these. Okay, and you've got the examples there in the NBBP. For abstract idea, make sure that you can explain that you have improvements to another technology or technical field. Say what are improvements to a computer or other machine itself. You're making the computer run faster. You're making the computer less error prone. Use of exception with a particular machine. Be careful here. You want to make sure that you're not just limiting the thing to a particular environment. Okay, the machine has to be tied up integrally with your claims. The differences here are slim, but we're lawyers. We hair split. This is what we do. You have the Diamond v. Deere is the important case here. You're looking at an Arrhenius equation. You're using it with a rubber curing machine to constantly update the cure times. Because yours was integrated with the machine, you're constantly updating the cure times, the times that the machine does things. This was considered not an abstract idea. But you're updating alarm limits in a catalytic conversion process by constantly measuring temperature, pressure, and flow rate. Abstract idea, not patent eligible. So according to this federal circuit, significantly more abstract ideas, your improvement in computer functionality, you're improving data security, you're improving display interfaces, novel and non-obvious arrangement of known pieces, sensor placement and data analysis, not just an abstract idea, internet content filtering, composite web page correction, or you're doing an ordered step, and that ordered step is different than the process humans use. Okay, if all you're doing is taking an ordered process that humans already use and you're throwing a computer at it, now you have an abstract idea. This, to me, and as some other people have said in journal articles, gee, this looks a lot like the obviousness analysis. Supreme Court has maybe incorporated a bit of 103 into 101. Arguably shouldn't have done that, but this is where we are. So the takeaways for this in overall, how are you going to get around 101, and what do you do when you get a 101 rejection? Look at your background section. It's hard to state what you are improving if you've not said what was before. Okay? Don't just treat your background section like it's unimportant. It is now important. Micro-infish was decided based on improvements that were cited in the patent. And they had said in their background section, here is how things are now. And they said, here is what we're doing differently. Here are the improvements in time based on computers doing things. That made it 101 eligible. Include evidence of other methods of solving the problem. In your background section, say, this is what we're doing. This is what was done in the past. This is how the problem was solved in the past. Here is what we're doing. Here is how we're solving the problem and we're improving the process. Emphasize the physical nature of the process and your system. The arguable difference in flock and deer is that you have rubber molding rather than just a generic alarm limit. And the court talked about, that in flock that they didn't talk about a chemical conversion system. They didn't talk about any of the chemical processes it works or the means of setting off or adjusting the alarm. Maybe if they had done those things, depending on how you read this case, you would have maybe gotten a different result. So get granular. Increase the specificity of what you have in your description. Make sure that the process you're doing is new and it's not just faster because you're doing on a computer. Even if it's, something that would take a human a million years to do, computer do it in 1 second, that's not going to be enough to get over a 101 rejection. They've got a bunch of cases that say a case citing humans to this long to do something, computer can do it this length of time, still not allowable. So that's the end for this. This is how you can get in to contact with me if you have questions on this. This is how you can follow Chambliss if you would like to do so on LinkedIn and Facebook. And this is the address to Chambliss here. And then, yes, the disclaimer. Always have to have a disclaimer. We are lawyers. I'm not rendering legal advice or services. So, all right, there we go. Thank you. I ran over. I apologize for that. If people are still here, I can certainly answer questions if there are any. As I say, this is a very complicated segment of law. So feel free to ask questions.
Wonderful. Thank you so much, Daniel, for that insightful presentation and for answering the question that you did during the webinar. So I'm going to go ahead and wrap up today. Thank you again for that person who submitted their question. And thank you again, Daniel, for your time. We always appreciate you being here. We want to thank you all so much for joining us for another Justia webinar. As we mentioned earlier, don't forget to take advantage of a powerful and free legal resource available to Justia Connect members, the Justia Daily Opinion Summaries. With these, you'll get next day email alerts with concise summaries of the latest court opinions in the jurisdictions and practice areas of your choosing. This tool helps you stay informed and stay ahead, and you can sign up at newsletters.justia.com. Thank you all so much for joining and have a wonderful rest of your day. Thanks so much. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.